All right, ladies and gentlemen, welcome to this episode of Riding Shotgun with Charlie. Today we are coming to you from the NRA annual meetings in Houston 2026. And we are doing some pit stop shows where we talk to people for a quick short time. And today we have with us... First I want to thank the NRA for having the Voices of the Second Amendment. They have a media center here with a lot of podcasters and video folks and all sorts of people making great content, and we get to be part of it. Which is really cool. So today we have with us Dan Schmutter, who is the world-famous attorney out of New Jersey. But you had a court case recently where you were not in New Jersey, right?
That's right. Yeah, we were at the Court of Appeals for the Fifth Circuit in New Orleans.
Yeah.
On a case called Knife Rights versus, it was called Knife Rights versus Bondi. It's now Knife Rights versus Blanche. As your listeners may know, Knife Rights is the second front in the defense of the Second Amendment.
It's the backup, right?
We know knives are arms, knives are tools, knives are things that everybody wants to possess and use. And of course, just like with firearms, the government is constantly trying to stop us from possessing and using useful and helpful tools and arms that we want to keep and bear. And so we're here fighting for knives as well.
It seems crazy that people wouldn't think that knives would fit into the Second Amendment. Do you know what I mean? Like, everyone's got a knife. We got kitchen knives. I guess they don't in England, but
right.
We've got kitchen knives. People,
at least they don't have the pointy bits.
Right. They got the plastic knives with the safety scissors, right?
Exactly.
Knives are just tools. And I remember a couple years ago, I went back to the Midwest into the house where I grew up to visit some family, and I was digging through a box of crap, and I found the little piece of junk knife that I had when I was a kid.
Yeah.
Right? Like, everyone's got at some point when you're a young kid, you feel like a man when you start to carry a pocket knife, you know?
Exactly.
Yeah.
Exactly. And some of us carry more than one, so there you go.
We only have 4 pockets.
Just so I can feel doubly like a man. I need the support. I need that.
My deal is this: I have one knife that is that I take out that's non-threatening looking, and then I have another knife.
Right, the one that counts.
Yeah, right. That's the one that it's my fidget spinner. It's really what it is.
Exactly.
So there's the Knife Rights is run by Doug Ritter.
Yes, exactly. Doug does a great job. They are very, very energetic and active around the country. They do tons of legislative work, really rewriting knife law around the country for years now. But from time to time, they need to go to court. Sometimes they just you can't get it done legislatively, and you got to fight.
What kind of laws do they have against knives?
Well, I mean, this case is about the Federal Switchblade Act. And as your listeners may or may not be familiar with the history of switchblades and switchblade regulation, but in the 50s, legislators all over the country, including Congress, got all nervous about gangs dancing around, singing,
right. A bunch of guys with switchblades break out and a song breaks out.
Exactly. The Sharks and the Jets and West Side Story.
We can thank Leonard Bernstein for this.
Exactly. How could we possibly have people dancing in the street singing with switchblade knives? We laugh, but it's crazy things like that get people riled up. I mean, we know, even with particularly with firearms, how media influence people's thinking about arms and about firearms and about knives and things like that, and it's complete fiction. But when people either get the wrong idea, or when politicians take advantage of those kinds of things and leverage that to get to get us riled up and give speeches about things that they know nothing about, and that they hope other people don't know anything about, then they get to oppress people and infringe on rights that we all should be able to exercise without even thinking about it.
Yeah,
and
totally.
So here we are in 2026, and we're dealing with a law from 1958 that's absolutely ridiculous, and it places all kinds of restrictions on the transportation, manufacture, sale, and possession of switchblade knives that are different from ordinary folding knives only in how they open. You hand a switchblade knife to many people, and they wouldn't even know that it's a switchblade knife without pressing the button and opening it, because it may very well look just like an ordinary folding knife.
They don't even look like folding knives. They just look like little rectangles.
Well, sometimes they do, sometimes they don't. And sometimes there's actually a great, as part of the record in this case, this litigation, there's a really great video that we put in the record from Doug, where he shows how the comparison. This was one of the main purposes of this video was twofold: to show the speed of opening of switchblade knives and how they're no different than the speed of opening of other folding knives. You might have a folding knife with a thumb stud, or with a finger tab, or with an assist.
Yeah.
And what he shows in this video, which is really wonderful, is how there's really no difference in speed of opening. But what's really stark is many instances when you're looking at the video, you can see the identical knife made, by a given manufacturer, and the only difference is that it opens with a spring instead of opening with a thumb, with a thumb flip, and you could not tell the difference unless you know what you're looking at. They look exactly the same. And they operate exactly the same, other than the spring versus bias towards closure. So it's astonishing that there is an entire layer of regulation and law differentiating between those two tools and those two arms simply because of a spring. That has no effect on anything, particularly has no effect on the Constitution.
Right.
So this is the world we live in, and this is what we're fighting against. And, as you know, and as your listeners I'm sure know, we're making great progress. It's a slog. As I like to say, it's a marathon, not a sprint, but we're hopefully beating them back.
Yeah.
We're making good progress on all fronts here. And this is one of the fronts, and we think we stand a good chance to do the right thing here.
That's good. So switchblades were not legal in Massachusetts for the longest time, and then a couple years ago they became legal. And go ahead.
Well, I was simply going to say, so knife rights had a material role in the KANJRA case.
Oh, very cool.
We from the SJC in Massachusetts, we did an amicus brief in the KANJRA case, which fortunately came out the right way. You always, when you go into a jurisdiction like Massachusetts, or as you know, I'm from New Jersey and New York, it's always dicey. You never know what's going to happen. I mean, look, you never know what's going to happen when you go into court anyway, right?
Right.
I've been doing this for more than 30 years, and I've long since gotten out of the business of trying to read people's minds. Yeah, exactly. Yes, definitely. But reading judges' minds and trying to predict the future is fraught with danger. So I've stopped doing it. But you go into certain jurisdictions or certain courts, and you sort of have to do the math. What are my chances? What kind of trouble am I going to run into that I'm going to have to overcome? How hostile might the judges be? How knowledgeable might the judges be? How thoughtful about the subject matter might they be? Might they take it seriously? Might they not take it seriously? And you go into a place like Massachusetts, and you really wonder, and you really have your work cut out for you. And one of the things that we did in the KANJRA case, in the switchblade case, was we felt that it would be helpful if we were to help educate the judges, because that's really what lawyers do, is to educate the judges, explain to the judges what is going on, what are the issues, how does this stuff work, and as an amicus curiae brief, which your listeners may recognize that term. It's a friend of the court brief, where somebody out from the outside, not one of the parties, somebody from the outside comes in and tries to offer some helpful information or some helpful analysis. And so we felt that it was we were in a position to try to help educate the court on switchblade knives and on some of the issues surrounding it, because so many people, especially in places like Massachusetts, are unfamiliar with it.
Yeah.
So. In the FSA, the Federal Switchblade Act case that we argued at the Fifth Circuit a couple of weeks ago, that's us, that's our case, and that's us advocating. So there's so many different ways we can try to be helpful in this fight. We can obviously, as I said, Doug and knife rights are regularly going into legislatures trying to change law that way. But then we can litigate our own cases. We can help with other people's cases. And it's with this kind of coordinated effort, with leaving no stone unturned and trying to help everywhere we can, whether it's knives, whether it's firearms, whether it's other kinds of non-firearm arms, you create this comprehensive battle, with the cooperation and help of everybody in this space and in this fight. This is how we make progress, and this is why I think we've been as successful. And I say we, the big we, like everybody in this who's in this fight, have been so successful so far because people understand how to kind of coordinate, tap into other people's knowledge and help wherever we can.
Yeah. After the out the front knives, we don't call them switchblades anymore. We just call them out the fronts, right?
Well, out the front is a type of switchblade knife.
Okay.
Really, the best way to describe it is an automatic knife. And I think in the industry, that's a very common way of describing. It's automatic in the sense that you don't have to do anything other than release the blade, right? So we talk about things like bias towards opening, bias towards closure. Bias towards closure means that there is a design feature of some sort. Maybe it's a detent, maybe it's something else that the blade wants to stay in the handle until you exert some kind of force on it, whether it's with your thumb or with your fingertip or with an assist. But it basically wants to stay inside. So you have to open the knife with some sort of exertion of force. Whereas you can have a bias towards opening, where the knife wants to open, but it's being held in place by some sort of latch or some sort of design feature. And so automatic knives are the knives that have a bias towards opening. They want to open, but they're held in place by something. And so that's why when you're typically with a switchblade or automatic knife, you often will actuate it by simply pressing a button, and you press that button and it releases the catch or whatever's holding the knife in place, and the knife opens. So that can be a fold-out knife.
Okay.
Right, it can be an out the front. It doesn't, it doesn't matter so much which way it goes. It's simply the idea that it's waiting to open if you let it.
Gotcha.
That's sort of your automatic knife. So of course, we use the word switchblade because that's the word in the statute, and so we sort of try to track the way the law reads, so that not because we prefer one term to another or versus another, but because we want to make sure people, including courts, understand what we're talking about. So we do talk about automatic knives, but because we're talking about the Federal Switchblade Act in this particular case, and most statutes, state statutes, also say the word switchblade, it's helpful for courts and for various people to understand what we're talking about and connect what we're doing to the legislation that we're trying to fight.
Gotcha. Yeah, I thought once it became. Oh, so here's the quick story. I went to the Great American Outdoor Show a couple years ago, and I walked by a table that had a bunch of out the front switchblades, and I was like, man, I can't wait for those to be legal in Massachusetts. And then they became legal. I went back the next year. I was there with our good friend John Petrolino, the Penn Patriot, and he went up, and he's like, so what do you want to see at the show? I'm like, I want to come home with a switchblade. And he's like, all right, cool. So he goes up to this table, and he says, listen, I have this review website. I live in New Jersey. I can't review these, but my friend Charlie's in Massachusetts. He can now have them. Do you have any for T&E? And they said, sure, absolutely. Here's a couple. Take it. We swapped info and stuff, and I carried them around. Again, it's the fidget spinner. I didn't know this, so this is part of the education of me. I held it up to an empty soda bottle. All right, I hit the switch to see if it would go through the bottle, and the blade popped off the track, which is a safety feature, right? So these aren't
exactly. It's exactly the same with firearms. The fiction that exists out in the world about what either firearms or knives or any other thing does is what drives the political war against the right to keep and bear arms. If you ask most politicians, most anti-gun politicians or anti-gun judges or judges who just don't know, or just any ordinary person who doesn't know, you would think an AR-15 is a magic wand that shoots fireballs.
Right.
and it's actually it's a struggle, because as litigators we have to decide what's the best way to educate either a hostile judge or simply a judge that's not knowledgeable about what these things actually are. The antis are so good at yelling and screaming loudly that, if we allow people to have ordinary arms that millions and millions of law-abiding people possess and use peacefully, the world's going to end, right? And you have to battle that, because people, again, and you go into court and you have a judge who's perfectly reasonable, perfectly objective, perfectly, willing to hear the facts and arguments, but all they know about arms, whether they're guns or knives or whatever, is what they see on TV, what they hear politicians screaming from the stump. And, it's generally a lawyer's job to educate a court, but when you have to educate a judge to overcome years and years of bias and misinformation, it's really, that you really have your work cut out for you. And that's much of what we do is that exact thing.
Yeah.
And to just dispel these myths and dispel this misinformation. And, that's our job in many respects.
Gotcha. How long, how did the case work out? Like, I'm sure it's, you present the case and then they go back and...
Right. And so this is a typical appeal in the federal system with a 3-judge appellate panel. Again, it's the Court of Appeals for the Fifth Circuit, so it covers Texas, Louisiana, and Mississippi. And the case was originally brought in the district court for the Northern District of Texas. And the judge in that court ruled against us, and so of course we took an appeal. And we got a very fair and very high quality panel. And that's the most you can really ask for. Is judges that are going to be open-minded, objective, and reasonable and fair with your issue. Mm-hmm. There's no guarantees. You sort of look at a particular set of judges, and you can sort of get a sense of am I going to get a fair shot? Am I not going to get a fair shot? Do I not know these people well enough to know whether they're going to be open-minded or fair? Mm-hmm. Fairness is all you really are looking for.
Yeah.
And so I think we have a fair panel here. I think we have judges who are going to really think about this stuff and try to make a decision that makes sense and is appropriate. And so that I can't really ask for more than that. And I hope we win. I think we did well.
Yeah.
But you never know. Like I said, I stop reading minds. It's never good. But there were some issues that we talked about. One of the issues that one judge was immediately wanted to talk about was the issue of standing. And for your listeners who don't know what that means, standing is sort of a gatekeeping legal concept that basically asks the question: can you even bring this case? Are you a person that has the constitutional injury that allows you to come into court and say, my constitutional rights are injured by this law, therefore I have a right to come to court, complain about it, and ask the court to give me relief in some form or another. Typically in these kinds of cases, an injunction that is an order that prevents the government from enforcing the law, and a declaratory judgment that the court declares that this is unconstitutional and unenforceable. And so that threshold issue is an issue that states and the United States, when it's deals with federal law, for example, like this does, like to throw in your way, right? If they like to throw roadblocks, if they can get a procedural, jurisdictional, as they call it, roadblock, then if they can stop you there, then they don't even have to worry about defending the merits of the law. They can stop you in an early stage that helps them, sort of marshal their defense of this law. So that was an issue that was brought up. I think we did a good job of satisfying this judge that we're in good shape on that issue. But again, we'll never know.
Yeah.
Oh, not never. We won't know until the decision comes out and we read. Did we convince him or did we not convince him? And there's 3 judges. So I mean, mathematically, we only need 2.
Right.
But because a win's a win. But so we'll see what happens. I think on the merits, our case is extremely persuasive on the merits. This is a kind of issue. This is sort of a fundamental kind of issue of common use. Mm-hmm. Your listeners may be familiar with the concept of the common use test that comes from District of Columbia versus Heller. The idea that when you're dealing with arms bans, like Heller was a handgun ban, this is a knife ban, the AR-15 case, the sort of so-called black rifle cases are bans, the magazine cases are bans. When you're dealing with arms bans, the test is simply, is it in common use? Is it typically possessed by law-abiding citizens for lawful purposes? If so, that's the end. They're protected, and you can't ban them. Mm. And so, and this is an issue that's percolating through the courts, and it's almost certainly heading to the Supreme Court, hopefully sooner rather than later, because we've got magazine cases, we've got, so-called assault weapon cases, and we have these knife cases. This is not the only switchblade case that Knife Rights has. There's a case that just got decided by the Ninth Circuit challenging California's switchblade ban, which came out against us. So, organizations like NRA and the other organizations, there's cases coming from a lot of different directions, and you want to kind of populate the field with multiple challenges, different jurisdictions coming from different places, so that something at some point piques the interest of the Supreme Court, because you never know what kind of case they're going to take.
Right.
You don't really know, do they like this one for this reason? Do they like this one? Is this law the better law they want to decide about? Remember Bruin, for example. When the New York State Rifle and Pistol Association versus Bruin was decided, there were multiple carry cases heading towards the Supreme Court. Mm-hmm. I had the case Rogers versus Graywall, which was a challenge to New Jersey's carry law. Bruin came out of New York. There was a Maryland case as well. And so you want to offer the court many perspectives to see which, because you don't know which one they're going to like.
Right.
Hopefully they like one of them. Same thing. So same thing with the switchblades. It's a arms ban case, and so we're the hope is to get the Supreme Court's attention with either our case or another knife case or another arms case, where they have to really make it clear to the lower courts how this common use rule works, that this is the rule, that governments, state governments or the federal government don't get multiple bites at the apple. If it's typically possessed by law-abiding citizens for lawful purposes, done. It's protected. You can't ban it. Whether it's, again, knives, black rifles, magazines, or whatever.
Yeah. So after they rule, how long does it take them to rule?
It can take. It's very highly variable, and I know. It's very frustrating to many people.
Do they have a deadline?
There is no deadline.
There is
and
no
so,
deadline. Okay.
See, one of the interesting things about the Supreme Court is that the Supreme Court disposes of all its cases by June. That's how they do it.
Right, clear the docket.
So that unless there's some weird, crazy thing going on, you're going to hear from them no later than the end of June, maybe first week in July. And so, as you know, there are two Second Amendment cases the Supreme Court is deciding this term. So we know that we're going to hear from them on the Walford case and on the Humani case no later than the end of June or first week of July.
Yeah.
With other federal courts, you really don't know. And I've had cases drag on for a very long time. I had my case Siegel versus Platkin, which is our challenge to New Jersey's Bruin response law, as they like to call it. It's one of the laws that states like New York, New Jersey, Maryland, Hawaii, California, they lost their mind. They absolutely lost their mind after Bruin, and they all passed these laws that said basically, okay, we have to issue a permit. Okay, now try to use it anywhere in the state.
Right.
Good luck. So we waited 2 years. That was argued 2023, and we finally heard from them in 2025. 2 years we were waiting. Makes you crazy, but
yeah.
And some cases are decided within a few months, and everything in between. So there's really no way to know. Look, I mean, in fairness, sometimes you think to yourself, "Oh my God, they're doing this on purpose." Maybe, but also they're extremely busy and they have a heavy caseload. Now, 2 years is a long time. In fairness, but you never know what they're doing. You never know what's going on. Especially in highly controversial cases, and of course, all the Second Amendment cases are controversial. It's always a struggle to. This is not a contract case. It's not a case about some mundane federal statute or whatever.
Right.
It's an important constitutional issue that's very, very, people are very passionate on both sides about it. So it's like, you never know what's going on within the court. Somebody's writing an opinion, somebody's writing a dissenting opinion. It's going back and forth among the judges. They're changing it, they're revising it. Maybe one judge is on the fence, so all kinds of things can go on.
Do the judges get together and hash this out by themselves?
Well,
do they like after you go up and you present your case, does the panel, the judges get together and say, hey, here's what we think and here's what I think, and then argue with each other?
They vote, and so I didn't clerk, so I can't give you for a judge. Many lawyers, after law school, it's some law students will graduate and then they'll clerk for a judge, and so they know all the inner workings of how this stuff works. I did not do that, so I can't tell you from personal experience. But
gotcha.
But generally, what's going on is they'll vote, so you'll kind of have a sense of where it's likely to come out, and then they'll write opinions. Now, I can tell you from the Supreme Court's perspective, they'll write opinions, and there might be lots of opinions going back and forth, and sometimes sometimes one of the justices will change their vote. If you have a majority, let's say, for one particular outcome, someone is assigned the majority opinion, and they're writing an opinion, they circulate it, and someone looks at it and says, "Can you make this change? Can you make that change?" Or you may have someone that voted the other way, and then they look at it and they may say, "Well, I'm persuaded by that," and they may switch sides. Occasionally, I'm sure that doesn't happen too often. But again, that's generally how these things kind of work. They communicate kind of with their written opinions and their drafts, and they go back and forth, and they say, I agree with that piece of it, but I don't agree with the other piece of it.
If it goes in our favor, what's the next step?
Well, it depends. So if it goes in our favor, then it's up to the United States government to decide whether they want to either seek what's called en banc review, which is review by the full Court of Appeals, the full Fifth Circuit, and they can. But that's discretionary. So they can they can file what's called a petition for en banc review, and that's basically a request for the entire court. And each Court of Appeals, each circuit's a little bit different in size, and then they will consider that. And if they have enough votes, then they'll take it, and they'll basically say, "Okay, we're doing a do-over." So that 3-judge panel opinion, that's gone. We're now doing it again with all, 14, 15, 11 judges, however, depending on which circuit you're in. So that's one path. Another path is they can file a petition for certiorari with the U.S. Supreme Court. And again, that's discretionary. And as your listeners probably are aware, the United States Supreme Court takes very few cases. And there are certain things that will get their attention, are more likely to get their attention. And certain situations where they're really not going to be that interested. That's sort of, again, a guessing game, although it's an educated guessing game, right? Because people who do this for a living have a sense of the kinds of things that they care about. For example, your listeners may be familiar with the concept of a circuit split. And that simply means that, because the federal system is split up into geographic circuits. And so, as I said, the Fifth Circuit is Texas, Louisiana, and Mississippi. The Ninth Circuit is kind of quite huge, but it's California, Oregon, Washington, Arizona, that Hawaii, that part of the country. And when you're talking about fundamental constitutional rights, or really issues of federal statutory law, it matters to the Supreme Court whether, if you live in Texas, you have certain constitutional rights, and if you live in California, your constitutional rights are different, right? So if the Ninth Circuit, for example, decides an important issue of federal or constitutional law one way, and the Fifth Circuit decides that same basic issue a different way, that's a bad thing, because your constitutional rights shouldn't depend on where you live.
Absolutely.
And so a circuit, it's called a circuit split. That's something that tends to get their attention. Not always, but often. That's something that they take very seriously. So, for example, I mentioned that in the Ninth Circuit, they decided the challenge to California's switchblade law, that's called knife rights versus Bonta, they decided that adversely to our position. So if we win here, well, arguably that's a circuit split. It's not the same law,
right?
But it's arguably the same constitutional issue, right? Because in that case, it's also that switchblades are arms in common use, and here it's switchblades are arms in common use. Now, again, if the issue, even though the issues that the plaintiff presents are the same, it doesn't mean the court decided the same issues. For example, in our case, we have the issue of standing. We have the merits, the actual constitutional issue itself. And so if the court decides a case on a different issue that isn't the same as the issue in the other case, maybe you don't really have a circuit split. So there's a lot of strategy. It's big picture stuff, right? The United States has to decide, if we win, then the United States has to decide what they want to do. Do they want to defend this statute? Do they want to go to the Supreme Court? The United States is in a different position than the states are, because the states, of what happens in a particular, let's say New Jersey is litigating a case and defending their statute, their magazine a law, because I'm also litigating the magazine challenge. That's Association of New Jersey Rifle and Pistol Clubs versus Platkin. Well, it would be Davenport now, but if they lose a case, if they ask the Supreme Court to hear it, do they run the risk that they're going to get an adverse ruling by the Supreme Court that's going to affect California's magazine law, right? This is the big long game that these people are playing, and that's why as folks in the Second Amendment movement, we have to be relentless, coordinated, thoughtful, smart, and aggressive because they're doing the same thing.
Yeah.
They're talking to each other. When I'm litigating against New Jersey or, whatever, they're talking to California, they're talking to Maryland, they're talking to all these states that have anti-politicians. And so we've got to be sophisticated and we've got to be aggressive. We've got to be smart, and so far I think we have been. It's, again, the NRA annual meeting is a great place for folks to talk and to think and to come up with ideas and to figure stuff out, because we have to. To fight this fight, we have to figure stuff out and we have to make it happen and we have to do the things. And so, it's conventions like this, meetings like this that really help that. Everybody gets together and gets to talk.
Yeah, we're going to be here anyway.
Right. Exactly.
That's awesome. All right, so let's wrap things up here. So we're waiting to find out what the court's going to say.
Correct. And as I said, it could be months, it could be a few months, it could be a lot of months, it could be whatever.
And there's no rhyme or reason to when they decide.
Right. Again, so much of it has to do with their workload, their caseload. Some of it may very well have to do with timing of the Supreme Court. Right now, as we discussed, there's the Walford case, which is the Hawaii private property case, the vampire rule, as they say.
Yeah.
And the Himani case has to do with the federal statute involving unlawful use of a controlled substance. In this case, it was marijuana. And so it's very likely that other federal courts that have issues that could theoretically be impacted by what the Supreme Court does in those cases may wait until the Supreme Court rules. Now, as I said, we know they're going to rule no later than June. So that's at least, okay, we're not waiting forever. But they could reasonably, some of these cases, they may have their opinions written, but they're not going to release them yet because, if they release an opinion dealing with engaging in a Second Amendment analysis, and then the Supreme Court changes something or tweaks something or does something a little different, then they'd have to go and change their opinion again, or something else would have to happen. So, some of these courts may just have their opinions in the can waiting. Maybe they have to tweak something. Maybe they have to come out the other way. So that's possible. So in this kind of situation where you have cases that you're waiting for the Supreme Court, people should not expect courts to go out on a limb and rule definitively on Second Amendment cases, because it probably makes sense for them to wait a couple of months. It's April, so it's 2 months.
We got a little bit of time, yeah. That's wild. All right, well, listen, where can people find everything Dan Schmutter? Well,
my law firm is Hartman and Winnicki. You can find me at hartmanwinnicki.com. That's HARTMAN. WINNICKI.com. That's my website. I am frequently on Anthony Calandro's Gun for Hire Radio.
Yeah.
I speak in various places from time to time, sometimes locally in New Jersey, sometimes nationally. So that's, keep an eye out, and that's where you can find me.
All right. Very cool. Well, listen, thank you very much for being on, Dan.
Charlie, it was a pleasure. It's always a pleasure. I'm happy to come talk to you anytime.
It's always great to hang out, man. I appreciate this.
Thank you.
All right. Well, listen, guys, I hope you got something out of this, particularly how court cases work and why it takes so long for them to happen and make decisions. We do want to thank the NRA for having us here at the Voices of the Second Amendment Media Row. If you've made it this far in the show, you should share it with your friends, because that is how we get the stagecoach across America. Thanks for listening, and we will talk to you guys soon. Thanks a lot.